Good evening and welcome to the Zoning Board of Appeals meeting of Tuesday, July 9th, 2024. Time is now 7:37. Sorry, we're a little bit late. One of our members is having trouble logging in, but we expect them here shortly. The meeting is being held via Zoom video conferencing under the governor's current executive order and is being recorded for broadcast by Boxborough TV. Our agenda and a link to the materials we'll be referring to tonight are available for download on the town website. There is a link to to the whole packet on the website for anybody wishing to look at those materials. First order of business is a roll call vote. For members present, when called, please state your name and that you are present for the record. I'll call you as I see you. Mark?
Mark Barbadoro, present.
Sean?
McCormick, present.
Michael?
Michael Toops, present.
Stefano?
Stefano Capera, present.
And we're just waiting for our alternate member to join us in a minute. So before we start anything of substance, we'll wait for him to log in.
We can do minutes if you'd like, Mr. Chair.
That's what I had on my... So minutes of June 11th, 2024. Alec, would you like to put those on screen, please?
Happy to do so.
And sorry to those of you waiting for the appointed minute because we can't start any hearing until we have our full quorum. Okay. Anybody have any comments on the minutes of June 11th?
I have nothing to add, and I'd like to make a motion to approve the minutes of June 11th, 2024.
Second.
Okay, moved and seconded. Any further discussion? Okay, hearing none. Let the record show that Dan Stuntz, who is our alternate, entered the room at 7:39 p.m. Okay, Than, we're just finishing off the minutes of June 11th. I don't know if you had a chance to look at them. Okay, so moved and seconded. Any further discussion? None. All in favor, roll call vote. Mark?
Barbadoro, aye.
Sean?
McCormick, aye.
Michael?
Michael Toops, aye.
Stefano?
Stefano Capera, aye.
Dan? Oh, actually, you don't vote on those. And White, aye. Did I get everybody? Okay. All right. So now, next item on the agenda is the hearing at 7:35 appeal of building commissioner's decision. I have to recuse myself from this, so I'm going to pass the torch to Mark Barbadoro and let him take it from here, and I will leave the meeting. So good night. Thank you.
Okay. Pursuant to Massachusetts General Law, Chapter 48, Section 8, and Boxborough Zoning Bylaw, Section 2.2.1, a public hearing will be held before the Boxborough Zoning Board of Appeals on Tuesday, July 3rd, 2024 at 7:35 p.m. to consider the application received from Attorney Paul Robertson from DeMora Smith LLP on behalf of 984 Massachusetts Avenue, LLC, as owner and applicant for an appeal of the building commissioner's decision as to the applicability of sections 2.3, 2.55, and sections 4.3.2 the Boxborough zoning bylaw. The subject properties are 38 Sarah's Way, map 14, block 4, lot 0, and 984 Massachusetts Ave, assessors map 15, block 5, lot 0, and 996 Massachusetts Avenue, assessors map 15, block 3, lot 0. And as the acting chair of the board, I've decided to appoint Than Stuntz to sit on this hearing. And I'd like to take care of one other procedural matter, and that is, as acting chair, if this meeting were to be continued again and I were not able to be around, I would like to appoint an acting clerk to act and act as acting chair when I'm not able to be the acting chair. So the board probably should have full input on this decision. So I was thinking that Stefano Caprara, who is our ranking member who has not been chaired since I've been on the board, might be a good choice, or perhaps Sean McCormick, who is just very competent, and I respect him a lot. So I don't know if either of these two candidates would be acceptable to the board. Does the board have any input? I'll start with Stefano. Stefano, do you have any desire to be the acting clerk and act as chair if I'm not around?
No, I'll step aside if Sean is willing to take that spot, and particularly given that I might not be able to attend the next meeting.
Okay. Sean, would you be willing to be the acting clerk?
Yes, Mr. Chair, I'll do that.
Okay, in that case, I'll entertain a motion to appoint Sean McCormick as acting clerk for this hearing. Will someone move? Okay, moved by Than. Is there a second?
Second, Michael Toops.
And second, Michael Toops. Okay, any discussion? Hearing none, roll call vote. Michael Toops,
Michael Toops, aye.
Sean McCormick,
McCormick, aye.
Than Stunts,
Stunts, aye.
and Stefano Caprara,
Stefano Caprara, aye.
and Mark Barbadoro, aye. Okay, this particular application has a circumstance that we don't often encounter, and it's something that I feel that we need to address before we go forward and open the hearing for input and deliberation. And that is, there is a question regarding the timeliness of the application and whether or not the timeline has been exceeded, and therefore the Zoning Board of Appeals may not have jurisdiction to hear this case. And this stems from, I'm going to defer to town council, but I think it is section 15, it might be 13 of 40A. I invited our town council to come to this meeting. That's Jonathan Eichman. Jonathan, can you elaborate a little bit on the section of law that speaks to timeliness?
Yes, Mr. Chair, thank you. John Eichman, Town Council. The chair is referring to chapter 40A, section 15. That section requires that appeals from orders or decisions of the building inspector be filed within 30 days from the date of the order. That's the applicable section. That has to be applied to every appeal. The board will take evidence on this question, but as we saw the order being appealed, that was dated March 25th. I believe that the actual application was filed to be verified by the board with the town clerk on April 29th. That would make it late. However, the board should request confirmation of the applicable facts from the town clerk and the applicant as necessary to make sure those are correct.
Thank you, Jonathan. So this is an unusual circumstance, and I would like to dispose of this question before we take any testimony. So it is, however, a public hearing. So what I'm suggesting is that we take testimony, but limited solely to the application and its timeliness. So that would mean to me that, of course, the applicant will be given an opportunity to explain his point of view, but it would also allow stakeholders to explain their point of view if they have a point of view on the timeliness of the application. It's not something that we would typically expect stakeholders to be commenting on unless they are well-versed in zoning bylaws. So with that in mind, I'd like to hear from the applicant's attorney and the applicant and anyone who represents the applicant. But I'm requesting that you just limit your testimony at this time to the to the applicability of the application, that its timeliness, and whether or not you feel that the board has jurisdiction to hear the application.
Good evening, Acting Chair Barbadero. It's a pleasure to be before you folks. Paul Robertson. I'm attorney for Louis Gutierrez and New England Tree, and I have the great pleasure of representing them in several different matters. I'm actually just, it's my first time before this board, so let me introduce myself. I live up 111 myself in Harvard, and my kids skate at Acton Boxborough, so I'm very familiar with the area in the site in question. I drive by it on a regular basis when I take my kids to the rink to coach them on a regular basis. I have, a general comment first, and then a specific comment. I fully understand the acting chair's instructions that were to limit our comments to the issue of the timeliness of appeal. I would state that, I have some specific comments about this, but I think that there are some equitable issues that I would like to have considered as well. But to the specific issue at first, I believe that I have the ability to share my screen. May I do that, Acting Chair Barbadero?
You may. Okay, we're seeing the a letter from our building commissioner to the appellant.
Yep, and as you see, this letter is dated March 25th, 2024. And I will start this off by saying that, when I initially came into this matter, I immediately went to the ZBA website to look up the board's rules and regulations and how they proceeded. And I was directed to section 9100 of the zoning bylaws. And of course, when I went to that, there is no 9100 any longer. They've been amended. So, I was at sea at first, of course, as to what the current rules of the ZBA are. I said planning, but I meant the ZBA. There were no rules, in fact. And once I mentioned this to the town planner, those were taken down. But there's still a reference in the website. When you go to about the ZBA, the instructions that are provided are to the old, town bylaws. So there was a difficulty right from the get-go into finding out exactly what the procedures were for the Boxborough ZBA. But I point to this letter because either the town seeks to enforce this letter in full or it does not, right? And so one looks at the first paragraph, the second paragraph, and the third paragraph, and these are all about the building commissioner setting forth exactly what the supposed violations are and what the requirements are. And then if you turn to that final paragraph, in writing, in his order, the building commissioner advises any person aggrieved by this enforcement action may appeal to the Boxborough Zoning Appeals Board within 30 days from the date of receipt of this decision, not the date of the order, but the date of the receipt. And, as the town planner knows, and I think that I've had the pleasure of also conversing with Attorney Eichmann, it was delivered, receipt was on March 28th is when my client got it in his hands. And so when one counts 30 days from that, you come to Saturday, the 27th, the town is closed. The Massachusetts law provides that when an office is closed, the date runs to the next day it's open. So the next day it's open is Monday, and we complied to the letter with the building commissioner's letter. So one is struck here. Okay, to the extent that the town wants to say, well, we're sorry, this is in fact the fourth time that the building commissioner has given you guidance, but it's incorrect. Well, then either this letter is invalid on its face and should be withdrawn and reissued, or it's not. It has to be enforced as a whole, or it shouldn't be enforced as a whole. So either I'm entitled and my client's entitled to rely upon this letter and what it says, or if it's flawed, it should be withdrawn and a proper one issued. So my suggestion is that I'm not sure that the town council was aware of the fact that this was the explicit instructions provided with respect to this order. And I'd reserve my rights to the extent that there's, any response to this. I'd like to reserve my rights to respond.
Well, I think that's fine. I don't want to interrupt you. Do you want to, would you like me to go turn to the town council or to the building inspector's council?
Yes, please. That would be helpful to me.
Okay. With the board's permission, I'd like Attorney Eichmann to help us understand. There is advice that's given on the last paragraph by the building inspector, and it does stipulate from the date received, and that appears as though it might be in conflict with Mass General Law Chapter 48, Section 15's requirement. So, Attorney Eichmann, could you please, and perhaps Alec, if you could share your screen, maybe you can pull up 48, Section 15 and put it up. I believe it's the first paragraph, if that's possible. And Attorney Eichmann, could you speak to the Attorney Robertson's argument that either the letter should be enforced in its entirety or it should be discarded in its entirety?
Yes, Mr. Chair, thank you. 2 points I want to make on that. Number one, building inspector did misstate the law, which we referred to earlier in Chapter 48, Section 15, that the 30-day period runs from the date of the order, not the date of receipt of the order. So that was an incorrect statement by the building inspector or the building commissioner. The point there is that incorrect statement is not effective to change the law. Building inspector cannot, by his statement, change a mass statute that says otherwise. So the law remains as is. The second point is that there is a considerable body of case law to the effect that statements of town officials cannot be relied on when the applicant has the ability to ascertain and the duty to ascertain the law themselves. And there was certainly time and opportunity in this case, as far as I'm aware of the facts, for the applicant to do that. They were not entitled to rely on the misstatement of the building commissioner, particularly as they consulted with legal counsel. So again, there is some case law on that. As to the final point that the council has made, whether the the letter should be withdrawn, in my opinion, that's not correct. The letter is a notice to the applicant and an order that they are in violation of the zoning bylaw. Council has said that the client received it, so they are aware of the building inspector's order. As far as the fact that he made a misstatement about the appeal period, that does not change what is said in the order that was received by the applicant, that he is in violation of the zoning bylaw. So there is no reason to withdraw that order, in my opinion. So I believe, again, in my opinion, that the board can proceed with the jurisdictional issue based on what is stated in that order.
Okay, thank you very much. I also just would like to say that the the building commissioner tries to give guidance to people to try and help them along with their appeals, and he isn't a lawyer. He's just a regular guy. Most building inspectors are like me. They didn't college. They didn't have any special training in order to do their work. And I'm just saying this because I don't believe there was any malice intent on the part of the building inspector. He just did his best with the information that he had available. So is Adam, Attorney Costa, on this call?
I am, Mr. Chair.
So this is your order. So do you have any comment? I mean, this is your building inspector's order. So would you like to make any comments on this?
I'm not going to add much of substance to the conversation, except to say, as you've indicated, in this instance, I'm representing the building commissioner, and defending the order that issued. With respect to the procedural issue, I generally concur with town council, really because I don't see any way that I can avoid that same conclusion based upon the state of the law. For better or for worse, the courts in Massachusetts have been relatively unforgiving when it comes to failure to meet the statutory deadlines for appeal, whether it happens to be an appeal at the administrative level to a zoning board of appeals or an ensuing appeal after a ZBA renders a decision to the courts. Generally speaking, failure to file within the requisite time frame constitutes fatal error and means that the body or the court lacks the jurisdiction to hear and to decide the case on the merits. And so I appreciate Attorney Robertson's argument that maybe there is some equitable case to be made for determining that this was a timely filing, but generally speaking, equity doesn't trump the law in the eyes of judges of the Commonwealth, at least in this area of the law. To Attorney Eichmann's point a moment ago, there is a doctrine that's recognized in a few states, but not in Massachusetts. This concept of municipal estoppel, where actions of a municipal official can be binding upon the municipality and can really prevent not just that official, but the municipality as a whole from taking later inconsistent actions. And if that doctrine applied here, you could say that the building commissioner is estopped and the town is estopped, essentially prevented from now arguing that the statute should control in light of the fact that the letter gave inconsistent guidance. But again, that doctrine is not recognized in Massachusetts, and in the 75, 80 years of case law that exists under Chapter 40A, there are all of 2 cases with incredibly extreme circumstances that don't mirror these, where that doctrine's been applied. So I tend to concur with town council's opinion that the appeal that's been filed is late. But again, I leave it in the hands of the ZBA to decide how you want to weigh the legal advice you're getting from him and from me against the equitable arguments that are being made by Attorney Robertson.
Okay, thank you. So we also have, I'm sorry, I see Sean. Sean, would you like to speak? Please
Yeah,
do.
Mr. Chair, if this is the right moment, I would. I'm just there's a land court case from several years ago. It's called Plotka versus House. And in that decision, the zoning board heard an administrative appeal that was taken, I believe, 71 days after the order issued. And the land court said, look, when this particular jurisdictional deadline is not the sort of hard jurisdictional deadline like filing an appeal within 20 days of a zoning board decision, and it's capable of being waived. And I'm talking about an unreported land court decision. There's also, I believe, an appeals court decision that has some similar ruling that a sort of unintentional waiver when the board unintentionally or sort of without realizing it hears the matter after the 30 days has expired, that once that gets to court, they're not going to kick it out for lack of jurisdiction. And the theory that was announced by the court is really a waiver theory. So it seems to me that if the zoning board is capable of waiving that statute of limitations inadvertently, then shouldn't they be able to waive it for good cause in a situation where maybe the equities do weigh in favor of hearing an appeal on the merits?
Is there someone
that's my suggestion.
Is this a comment, or would you like an answer from our attorney or from Attorney Costa or from Attorney Robertson?
Well, that's a comment, Mr.
Okay.
Chair. The comment is that I believe there's case law to support the position that this is a waivable statute. rather than a unwaivable, absolute statute. And I'd be happy to share that case citation.
Okay, thanks. Well, why don't we, before I have the rest of the board respond, I'd just like to let Attorney Robertson respond to what has been said so far. Attorney Robertson, please.
Thank you very much, Acting Chair Barbadero. I've heard the comments from Attorney McCormick, Attorney Costa, and Attorney Eichmann, and in general, I'm in agreement with each of the things that they said. I don't think that any of the law is misrepresented there. I think it's a bit of an overstatement to say that municipal estoppel isn't recognized in Massachusetts, and I point to Elder Care Services versus Zoning Board of Appeals of Hingham, which is a Mass Appeals Court case in '84. Municipal board is stopped from contending that constructively granted special permit use was unauthorized by the zoning bylaw. Worcester versus Board of Appeals of Spencer. That's another Massachusetts Appeals Court case. Municipal board barred from first raising claim jurisdictional defect on appeal. And there's a third case, Colangelo, as well, 407 Mass 242 from 1990. So there are circumstances when a town is stopped. And I'm familiar with the cases that Mr. Eichmann references, where it says, hey, look, you can't rely upon, a town official, when, the statute is an absolute guillotine. But I would caution about, complete reliance upon those cases, because they are instances where a town clerk or an administrator says something to somebody over the counter. They typically are that, hey, look, you have this extra time. They're not to the extent that this is, I have nothing but total respect for Mr. Cataldo, and the pressure that he is under in getting these letters out, and nobody's saying that he's an attorney, but this has the force of an order. And this is not just a statement in passing and in fact, I relied upon this. I relied upon his language that, he had 30 days from the date of the receipt of the decision. So I most certainly, if I had, believed that the board was going to have a different deadline, I would certainly have complied with it. I will also comment that the cases do rely upon the intent of the speaker, and they talk about whether there was an intent to cause reliance on the language. And so some of these say that, there was no intent to mislead. I don't think there's any intent whatsoever on the part of Mr. Cataldo to mislead, but I certainly think there was an intent of him to have reliance, to provide guidance here. And I think that the force of an order has something more than, simply, a comment in passing over the clerk's desk. I will comment too that the way that I think that this could be remedied. I heard Mr. McCormick's comment, about the waiver, and I think that Mr. Costa and Mr. Eichmann would say the same thing, that I don't think that it can be waived in that that you can simply waive it without good cause. I think that here, in fact, there is the argument that the equities require or would cause the town to allow this appeal to be heard. And I would suggest, as I said before, that the way to get around this, it would seem to me, is to simply reissue the order and say that it was defective on its face, and that way. And I don't believe that, given that it's my client that's trying to move on here, that there's great prejudice with having him get a new order. The appeal goes forward, and it can be remedied in that way. And I would say too that one of the challenges that I've had is that I've had to address this. My understanding is the town had been aware of this issue 2 months ago, and I just received notice on Monday. So I think it's a bit of a challenge for me to come up with the complete knowledge of the arguments here. But I think again that the equities certainly point to the town allowing Mr. Gutierrez to proceed with his appeal.
Thanks, Attorney Robertson. So why don't we open it up to the rest of the board? Does any of the other board members have a question or comment? Okay, we may come back to our other board members, but in the interim, I'm just going to check and see. Oh, I see Stefano has a question or comment. Go ahead, Stefano.
Yeah, just two comments. First, I think if we are proceeding with answering the jurisdictional question, I think if there's any interpretation that allows us to move forward, we should err on that side. I mean, that's my position, as opposed to taking a hard fast approach to the rule, just because of the detrimental effects it has on that final decision. And the alternative too is with regards to the actual notice, as Attorney Robinson mentioned, if there is an option to withdraw it and reissue it and alleviate both concerns, and then start afresh if that is on the table, I think that kind of alleviates everyone's jurisdictional questions at this point, and then we can move forward without concern.
I think that is up to the building commissioner if he wants to write a second order. Michael.
Right. No, I understand we don't have the authority to do that, but I'm saying if that resolves this larger issue.
Well, I'm actually not saying we don't have the authority to order him to do it. I'm just saying that I think at this point he should probably reissue his letter if he decides to, if he's adamant against it. I'm not going to weigh in on whether or not we have the authority to take it from him, but Michael.
I guess I come back. So, with response to having the order rewritten, if the only defect in the order is the date line, I fail to see why that needs to be restarted per se. Though I do come back to the question of whether or not the board has the discretion to waive the required date based on equity reasons, and if so, I would be tempted to proceed in that direction, but I don't know whether the board has that discretion based on the discussion so far. It appears that the board may have that capability based on legal counsels, but I guess I'm struggling with that. Over.
Thanks, Michael. I see Stefano's hand. There may be others. I don't have my screen set up the way I normally do. So Stefano, go ahead, and I apologize if someone else had their hand up.
Yeah, I just want to kind of reiterate or confirm that from what I got was town council was suggesting or taking a position that there was no real leeway with their opinion with respect to the dates and how we interpret it, and the discretion of the building inspector or building commissioner to change the rule simply by the language that's used in the order. So, I don't think that, to me, that was clear with respect to their opinion as to how we should approach a jurisdictional question.
Is that directed at town council? Do you want a response from him, or are it's general comment?
Town council can affirm that or provide. If there is some movement there with respect to equitable reasons or some other reasons.
Yeah.
Jonathan, can you state your opinion again?
Yeah, Mr. Chair, I'm happy to address that. I heard Member McCormick's comment about Plotka. It certainly, I picked my ears up because I'm certainly aware of that case, unfortunately. My opinion, Stefano, I agree with that. My opinion remains the same. I agree Plotka did what John said it did, which is it, relying on a couple of appeals court cases, said, well, if the ZBA if they waive their right, they can do that. They have that ability. I think that's an extremely slim read, and I think, Sean said as much. It is there, but it's never been followed by any appeals court case, and there's a lot of other law to the contrary. So I can't tell you that by any means. If you went ahead and said that you were going to proceed past this and not take a position that jurisdiction was lost because this was waived, I can't tell you that that will be easy to defend. I think it would be difficult to defend. I can't say it's impossible. Lawyers don't generally say that, but my opinion remains the same, that the better position still is that this is not a waivable issue. It's a jurisdictional issue. It's based on the date of the order and the date of the filing. And I think the Plaka case is an outlier, but perhaps maybe it's an outlier waiting to become something more. So,
thanks, Jonathan. Is there any other questions or comments from the board? Attorney Robertson, I'm going to give you the last word, but I did want to just check with the rest of the room, and I will definitely get back to you. Is there anyone else on the call that would like to speak to the timeliness issue or the jurisdiction issue? Any member of the audience that wants to weigh in can, because this is a public hearing and they have a right to be heard. So is there anyone on this call who would like to speak on that matter? If so, raise your hand. If you can't raise your hand, call out, wave, something, let me know. Okay, I'm seeing nobody at this time. Oh, I see Kathy Vorse's hand. Kathy. Can we unmute her if she's muted?
Kathy, you should be able to unmute yourself.
My apologies. I was struggling with the technology as usual. Mr. Chairman, I am, as you probably well know, a member of the Planning Board. And I would like to put a question to Town Council and or Attorney Costa, that if we leave this and walk away from jurisdiction, what is the net effect to this appellant, to the ZBA? As a member of the Planning Board, I would like this person to get the message that the issues that were conveyed to him, we would like to see him comply with. And I don't know what the best way to put that in the end zone is. But if council can respond as to, you know, where it leaves him, I'd like their opinion.
So, Kathy, I think you're talking about other permit issue in town that is the applicant is facing. Is that right? Like a stormwater permit?
Yes, he's facing that, but also these are zoning issues that we are concerned about, the site plan. I mean, I, as a private citizen, take my own trash to the dump and drove by there and of my own accord noticed substantial changes on the property. I was one of the planning board members who agitated for an enforcement order by the building inspector. And when finally we were given a copy of the original communications by Mr. White and Mr. Gutierrez, I think I find no fault with Mr. White's representations. You know, they seem fair on their face. But as soon as I read the line, I hope to be an asset to the community and make substantial improvements to this property to make it more visually appealing. Substantial improvements, to me, triggered a red flag as far as the zoning requirements. And I
Kathy, I beg your pardon. I'm sorry to interrupt you.
No, I wanted to see, what he meant by that.
The only reason I want to is because we're getting a field of the original question that I'm just trying to dispose of And because one way or another, if it's disposed of one way, then we would end this hearing at that point. But if it is not, then we would, I'm hoping that you will speak up again, but on the specific issue. So but I'd really like to limit it to the issue right now is whether or not the appeal application was timely. So I'm going to get back to you. Okay. So just stay on the line. Is there anyone else who wants to speak to the timeliness? Sean does. Go ahead, Sean.
Thank you, Mr. Chair. I was sort of reminded by Ms. Vorse's comments that, the facts surrounding this case are not a great look for town officials in Boxborough. I think that Attorney Robertson's memorandum that was submitted has some troubling allegations, and I'm not. They are what they are, and I think if we reach the merits, we'll dig into them. But I think that allowing this order to stand without really being examined on a jurisdictional defect, when in the background there are these issues of the sort of relation between town officials and town government and town citizens, it's troubling to me. And I guess I would just urge my other board members that if there is a path to jurisdiction, that path should be taken, and this matter should really be decided in a full, fair hearing on the merits.
Thanks, Sean. Attorney Robertson, you will have the last word.
Thank you very much, Acting Chair Barbadero. I think I'd just like to, comment holistically that we do hope the appeal goes forward. We did have some concerns with the way that this is proceeded, but I think that I want to really emphasize that, that Mr. Gutierrez and his company really do seek to be attribute to the community. They recognize that the town, although they have concerns with some of the ways that this has gone about, I think that they recognize that they absolutely have a desire to comply with the relevant law here. And one of the reasons that I reached out to Attorney Coster and Attorney Eichman, who I've had wonderful conversations with and represent the town quite ably, is to try to have discussions about how we can reach a resolution here without me having to, throw people under the bus and make arguments, but at the same time, get this done. And I think that, one of the options, again, I think is that, if the one option, it seems to me, that covers everything, is to issue a new letter tomorrow that cures a defect, we'd have our appeal letter in the next day, and we could go right back to the hearing schedule. And I think that solves the problems. I respectfully believe it addresses Attorney Eichmann's issue, because you're saying the town is basically saying, yes, we recognize the defect in this letter, we're withdrawing it, new one issues, and on we go.
Okay, thank you, Attorney Robertson. So does the board have any questions for either Adam Costa, Attorney Robertson, or Jonathan Eichman, or anyone else? And if not, then maybe we should try and dispose of the issue. Van.
So if we say, it sounds like there are sort of three paths. One, we say, it's too late, sorry, on we go, which sounds like the next step is, okay, we don't, me as an applicant don't believe it, let's head to court. There's one where we say, gee, it's a day late, best process is, most honest process is, we know you are arguing it, we're okay with that. Let's figure it out. But then there's the question of whether that is allowed to be done. And then there's a third path, which is we say, hey, we are going to withdraw that letter, expect one tomorrow morning, and then the attorneys can send us a response, and we essentially reschedule this hearing to be dealt with, and it clears up those things. Are those sort of the three paths that we are looking at? So this is sort of questions to the board, and I mean, so I guess for our perspective is, what's both best for the town and what's the most right thing to do, and that can be right legally and right, from a how do we as a town want to act? So I guess that's where we're at. That's where I see we're at.
Okay, thanks. Thank you, Than. Okay, I think at this point, is there any other discussion that we want to have regarding this issue, or should we just decide it? Anybody have
Mr. Chair, if I could make a comment here, it might be somewhat helpful.
Please.
I think, and I heard, frankly, the planning board members' comments actually touched on this, and I think it's somewhat important. The question is, what are the results if we go one direction as opposed to another? And I'm not suggesting that the board should take one direction or the other, whether it should pursue enforcement, it should deny jurisdiction. That's really up to the board, and I understand why the board would want to get at the substantive issues underneath this, and that makes perfect sense to me. But, you know, my obligation here is to tell you what the law is and so that you can use that to make your decision. So one of the things I think you need to think about is that the building inspector's order, which is being appealed here, says basically two things. That you have expanded the use of your property beyond what's legally allowed. And what he's saying is he's acknowledging, at least for purposes of this letter, that there is a non-conforming use on the property that has been expanded beyond where it can be done without approval of the various zoning boards. So he's saying that expansion requires site plan review, and it requires a permit from the ZBA to expand a non-conforming use. Those are obviously arguable. But if he is incorrect, if the appeal goes forward on that issue and the board decides that the building inspector is incorrect, then the use that's there, the expansion that's there, will continue, as I see it, without site plan review and without a permit from the ZBA. In other words, the decision would be, yes, it's allowed. So there would not be further zoning enforcement or zoning permitting procedures that would take place. That's really what's on appeal here. So if you want to get into the issue, you're going to have to look at whether this is truly a non-conforming use, and if so, is it what happened here on the site? Is that an expansion of that use? Does that require approval of the zoning board of appeals? Because some expansion is allowed without approval. And site plan review is a zoning bylaw. If this is a protected use, if it expands, does that expansion require site plan review? Those are questions that you'll have to look at. So the potential is, just last comment on this, is the potential is that if the appeal is granted, the building inspector's order is overturned, the conclusion would be that what has been done on the property isn't allowed use under the zoning bylaw to this point. Just so the board is aware of that. Again, not saying the board can't go there. It certainly can. You have my opinion on, the potential dangers of the jurisdictional issue. But other than that, that's one of the possibilities.
Thank you, Attorney Eichmann. And I would also like to add to that and say, and then I'll get to the many hands that are up. In the event that this enforcement action is upheld and we say that this is not timely, so we cannot hear it, therefore the building inspector's decision stands, the applicant can come in the following day with an application for special permit, both as a non-conforming use and also under the use table of the bylaw. There is plenty of wiggle room for the applicant to come in and make their project, get approval for their project, provided that they meet the zoning bylaw. So this is not the end of this of the appellant's opportunity to run a business. It's just whether or not we have jurisdiction to hear it. So I just wanted to add that to the conversation. And I believe in order, I've got Attorney Robertson and then Attorney Costa. So Attorney Robertson.
May I defer to Attorney Costa, please? I think
Sure.
we have something to add to what Mr.
Okay.
Eichmann just said, and I can respond to that.
Sounds good. Okay, Adam, please go.
Sure. Thank you, Mr. Chair. So I just wanted to add a couple of points to those that have been made by town council. And again, his role here is to represent the interests of the board and to give you legal advice, provide you with his opinion. Board members can choose to follow that advice, can choose not to, can choose to favor the equities over the law, can choose to read the law more expansively. Even he has said that's up to you. And so in a similar fashion, my role here is to represent the interests of the building commissioner. And so in that respect, I want to really say a couple of things for the benefit of the board. The first is, and it relates to something that we began discussing 45 minutes ago, but we've come back to it a few times, and this concept of outlier cases, and member McCormick referenced the Plotka case. I'll be honest, I remembered the name. I remembered it was a case out of Swampscott. I didn't remember exactly what it had said. I hadn't read it in a long time, but all of us lawyers, when we do these Zoom meetings, can look like whizzes because we can pull it up on Westlaw real time here and we can read it to ourselves. So I've got it up. I'm looking at the case. I'm remembering what it said. My read of Plotka is a bit different. My read of Plotka, certainly it doesn't say anywhere in that case. It was a land court case, so it's a trial court decision. It doesn't say anywhere in the Plotka case that the board, a zoning board of appeals, has explicit or implicit authority to waive the jurisdictional defect. The issue in Plotka was that the board simply didn't address the jurisdictional issue and went right to the merits. And so by the time the case got to court, the question for the court was, well, is this even properly before the court because the ZBA never had jurisdiction because there was an untimely filing? And essentially Judge Sand said, well, too late to argue that now. I liken it to what we lawyers are told when we get to the appeals court. We want to advance a new argument that was never advanced in our trial or in our post-trial brief, and the appeals court says, you waived that argument, you chose never to advance it before, you can't advance it for the first time on appeal. Judge Sands applied a similar reasoning and said, and I'm going to read it to you, the ZBA may waive their right to assert lack of jurisdiction if they fail to timely object that the appeal was not brought within 30 days. So if the board chooses not to object, in this case, it wasn't even a choice. I don't think the board knew it was doing it. Then the board isn't going to be permitted to do that later. So I just bring this to your attention because, again, while I'm not going to tell you what you've got to do here, number one, I'm not representing you. Number two, that wouldn't be my role anyway. I just want the board to be aware that if you choose to overlook the jurisdictional issue and address the merits of the case, you'll not be permitted later to rest on jurisdiction. You'll not be permitted later, or your counsel won't be permitted later, whoever it is that's representing you if there's ensuing litigation, to argue that, well, we didn't even need to get to the merits because there was this jurisdictional defect, and so it never should have been before us. Once you choose to put it before you because you choose to address the merits, you've essentially waived the right to later argue that jurisdictional defect existed. So I just want you to be sure that you understand as you move forward that's the risk. The second point I want to make kind of goes to where do we end up at the conclusion of all of this? You deciding that you lack jurisdiction and therefore not ruling on the merits of the case versus you considering the merits of the case and issuing a decision on those merits. And Attorney Eichmann did a nice job summarizing it, but I'm gonna state it slightly differently because I think that this is important. If you choose to not take action on the merits of the case because you determine you don't have jurisdiction, from my perspective, and I don't know if Attorney Eichmann agrees with this or if he was characterizing it differently, the decision of the zoning enforcement officer, the building commissioner, stands. And so the rulings that relief is required or that change in use can occur without relief or that site plan review is required, those rulings stand. Essentially, the applicant has lost its ability to challenge those rulings. Now, Attorney Robertson may appeal the jurisdictional issue if this board decides to not hear the case on the merits. Certainly that's his right, that's his client's right. But if that's not appealed or if it's appealed unsuccessfully, then the decision of the building commissioner stands and the rulings of the building commissioner stand. And if the applicant doesn't comply with those rulings, the town would be well positioned to enforce those rulings. And if there were a later attempt to defend against those rulings on the merits, the town would argue that ship has sailed, that opportunity has passed because there was not a timely appeal filed. The appeal was filed after the 30-day period run. So that's option one if the board chooses to rule on the jurisdictional issue and to determine that it lacks jurisdiction. Conversely, if the board determines it's going to reach the merits of the case tonight or at future meetings and addresses the merits and determines on those merits either that the decision should stand or that the decision of the building commissioner should be reversed, well, then that outcome is the definitive outcome, obviously subject to appeal. But you have a decision then on the merits and you've lost the opportunity to rely upon the letter as it stands now as unappealed within the requisite time frame. So I don't know if I complicated things or made them simpler, but that's the outcome based upon whether you choose to address the jurisdictional issue and deny to proceed further, the opportunity for the applicant to proceed further, or you choose conversely to reach the merits and see where that leads.
Thank you, Attorney Costa. Attorney Robertson?
Yeah, I would agree with the statements of both Mr. Eichmann and Mr. Costa. I'd only add that, to the extent that the board does consider the appeal, I don't necessarily agree that it's a zero-sum game, that the Board of Appeals, the Zoning Board of Appeals would say, look, either we're going to uphold the letter in its entirety and require you to submit a special permit, or completely reject it and not require a special permit. One of the issues here for my client is that the letter determines not only that the way the bylaw reads is that if you engage in any change whatsoever in a place that has a pre-existing non-conforming use, you're required to arguably come in and seek a special permit. And he's concluded already that the work being done is well above the pre-existing non-conforming business. So one of the issues that my client has with this order is that to some extent, the cart is before the horse. My client has never been able to discuss, what his uses are, what he understood the prior uses to be. I think I want to reiterate too that it's my client's end game here to reach, have an accord with the town that his uses, his site plan is approved by the town. But the problem with this particular order is that it makes findings that, again, put the cart before the horse without him having a chance to explain his position. And I also want to make really clear that we did, in fact, have some substantial concerns to the manner in which, my client got here with the procedural aspects of the case.
Okay, thank you, Attorney Robertson. Does anyone on the board have any further comment or Michael?
So trying to understand the various options. If the board declines to hear for on jurisdictional purposes, and it is appealed, and it is the jurisdictional issue is appealed, does it come back before the board for a future hearing as an appeal against the building inspector? So I guess that'd be a question for town council or building inspector council.
Jonathan, do you want to address that?
Yeah, thank you. Thank you, Mr. Chair. So if the board decides that it does not have jurisdiction to hear the appeal and denies the appeal for that reason, an appeal can be taken to court from that decision directly to court. The court would then decide the issue decided by the board, which would be, did the board have jurisdiction should the appeal have been dismissed? If the court decides that the board acted correctly, then that would be the end of it. And as Attorney Costa said, the building inspector's order would stand as stated. If the court, however, decided that the ZBA was incorrect, that in fact, the appeal, there were equitable grounds for saying that the appeal was timely filed, that the ZBA should hear it, I would expect that the court would then send it back to the board to hear the appeal, because if the board simply denies it on a jurisdictional ground without ever hearing the underlying facts and making a decision on the claims that the appellant is making, then the court would not make those themselves. It requires the board to look at those, and that would come back to the board. I would expect that to happen in that case.
But it's not guaranteed.
No, nothing's guaranteed. The court, no, that's just the way it is.
Get your quarter out and flip it and see what happens.
I think that's a fairly safe statement, but yeah, no, not guaranteed.
Okay, thanks. Any other questions from the board? Or comments? Any comments from any member of the audience who has not yet spoken, or has spoken in the case of Kathy that still has questions about the jurisdiction or the timeliness of the application? Okay, I'm not hearing any. Is there any other comments that any board member would like to make? Okay, I'm not seeing any. So I'm just going to comment on a couple of things. That this opinion was not pushed forward by me. This came from counsel to me, and I have not influenced him to come up with this kind of an answer. I've had very bad experiences in the past by ignoring the advice of town council. And, from my perspective, it's not a question of whether it's right or it's wrong. If the law tells us that you have a set time period, then that's what needs to happen. You need to follow that time period. And the law itself may not be equitable. An example might be when a building commissioner issues a building permit and perhaps an error due to a zoning issue, and the neighbor doesn't notice it for a month and then comes in. Well, the building inspector's order was that the person was allowed to build, and the appeal period has been exhausted. I've seen that happen before, personally. So from my personal perspective, from what it's worth, the opportunity to appeal has expired, and I don't believe this board has jurisdiction. So now that I've said my piece, and I think we've heard from every member of our board, can we get a finding of fact? Would someone be willing to make a motion? And then we can move forward one way or the other. We can either close the hearing and vote, or we can proceed with further testimony. Michael Toops.
Quick point of order. If we can't close the general hearing, I would think, if we're just going to vote on the whether or not we have jurisdiction, because further hearing may be dependent on the outcome of that vote. Until we know the outcome of the vote, the hearing has to remain open.
So I sought advice about this with town council, and he is here, and he can correct me if I make any misstatements. But what I was looking for is a finding of fact that either the application is timely or it is not, and that so a motion, for example, a motion that I move that the application was timely, and then if there was a second, then we would have discussion, and then there would be a vote. And after that vote, so this, in other words, you can hold votes during a hearing. And so that is a finding of fact. The hearing is open. If more than two members, or actually if two members said that it was not voted against timeliness, I would seek a motion to close the public hearing at that point and hold a vote. The reason being is because there isn't enough, you need a supermajority, 4/5 majority, to to overturn the building inspector. At that point, we wouldn't have it. So we would hold a vote, and that outcome of the vote would be if the two people who thought that the application was not timely, that would end the matter right there. It would be done. So all we can do is by supermajority is overturn in whole or in part the building commissioner's determination.
Yeah,
Does that
Mr.
make
Chair,
sense?
yes, Mr. Chair, just briefly, if I may, that on the finer point that Michael Toops just made, I think that would be wise. I agree with everything you said, but I don't think I would wait to close a public hearing until you actually have a final vote on the application. You can certainly do that. There's no magic that you have to close a hearing before you take a vote. So that would be my only point. I would wait. If the vote, you may have a finding of fact, but you may not get the vote on jurisdiction. I would wait until that vote was taken.
Before you close the hearing, get a vote on finding of fact on whether or not.
Absolutely.
Yeah, that I was trying to say that. I may not have done so. And I'm going to try and go in order. I think I have Attorney Robertson. Go ahead, please.
Thank you, Acting Chair. My only comment would be that I would respectfully request that the board consider, I think, a resolution that solves all of our problems. That, you know, that there's either a thumbs up or a thumbs down vote on this particular letter, but one of the options would be that the letter is simply reissued tomorrow, and my appeal letter comes in 2 days later. And I say that not only for the practicalities of it, but I will of course have to speak to my client. But he considers the equities pretty strong, especially in light of what's happened here in the past. And as Planning Board Member Vorse mentioned, there's a desire to get this resolved, and I don't want to go to court. That doesn't help anybody out, and it's just going to delay the process further. So I would respectfully suggest that if the ZBA would consider simply, correcting the letter, making the determination that, hey, look, there was a defect, reissue it. I think that would solve the problem. And of course, the town, you're right, has no obligation to do so. But I think that shortcuts my need to go to court to challenge this and at everything, if my client instructs me, and it moves things along more quickly.
Thank you, Attorney Robertson. And I'm just going to use my own authority here just to say, if first of all, it's unclear whether we can order the building inspector to issue a new letter with a different date on it. And if we did have that, it sounds to me like something akin to overturning a building inspector's finding, and that would take a supermajority vote of this board, if it's possible at all. So, and I don't know if we're at a place where we're going to ask that just yet. So I just wanted to raise that point, but certainly a board member could ask counsel about that. So I think Stefano's next.
Yeah, so two things. First, with the findings of fact, I mean, I think there's a distinction here between making a determination if it's timely and whether we have discretion on determining if it's not timely, do we still have jurisdiction? So those are two separate things. And I think the first question is clear. The second question is the one where we have various opinions being made as to waivers, as to discretion, as to equity. So I think simply saying if it's if it's not filed timely doesn't necessarily close the hearing or resolve this, because there may be the discussion of us being able to move forward with the jurisdictional question regardless if it wasn't timely. Felt timely. But the second one, and maybe again, this is to Attorney Robertson's point, is there the option to continue the hearing to not order the building commissioner to do anything or make a decision on that, but provide some discretion as to if they make that decision on their own accord?
We have our own timeline that we have to follow too, which is 100 days plus whatever time the applicant would mutually agree with us if we decided to.
Right. Naturally, I would assume the applicant would mutually agree to whatever extension is necessary to allow for that option to occur.
Okay. Thanks, Stefano. Anything else? No? Okay. Michael?
With respect to the question of whether a finding for the board or whether it's timely, or whether we have jurisdiction, would that actually require a supermajority because it's not an overturning of the decision itself?
No,
Over.
the forcing the building commissioner to issue a new letter with a different date and
No,
or
I'm not asking that question. I'm asking the question, if the board decides it has jurisdiction or not, does that motion require a supermajority? Because it does not overturn any decision of a building official.
I would think not. I think that would probably be a simple majority. However, if either of those two questions were to come up with two members of the board saying dissenting, right? Then those two members would theoretically vote against the overturning the building official's decision generally, and that would result in the decision standing, right? Because to overturn the building, Sean disagrees. Sean, please.
Yeah, sure. I just, Mr. Chair, I would just point out, I mean, I think the merits and the jurisdiction are completely separate. So someone may be inclined to, to assert jurisdiction and inclined to uphold the building inspector. So I don't necessarily think that the way a board member votes on the jurisdictional question is any indication. And maybe I'm saying this to you, Mr. Chair, but also to the applicant. There's no tell here. The jurisdictional question and the merits are, I think, totally separate.
Okay, but Sean, may I just ask you one question?
Sure.
If you didn't think that you had jurisdiction, right, would you then vote for overturning the building commissioner? Or would you be voting to do something that you thought you had no jurisdiction on?
If I did not believe I had jurisdiction, I think that if the board asserted jurisdiction and I was outvoted, then I would approach the building commissioner's order with an open mind.
You would change your mind?
Okay. Potentially.
No, that's a fair...
expansion of non-conforming use is a complicated and fact-intensive inquiry, and I'd like to hear the presentation. There's a lot of stuff in the packet. There's a lot of materials to go through. I think this is a complicated and tough decision, but I do think I do think that it is a decision that we're capable of making and that we should make. And if as a sort of policy thing, upholding the building commissioner on the merits, I think is better policy than a sort of de facto uphold or affirmance based on a jurisdictional defect.
Understood. Thanks, Sean. Okay, so where do we want to go? I'd like a finding of fact on this matter. Would anyone like to make a motion on the finding of fact?
I have a question before that. So if we find that, yes, this was out of, out of date, and gee, why don't we continue this hearing for 30 days or something like that and see if the building commissioner is willing to reissue for the benefit of the town or anything like that? Is that overriding the building commissioner? How does that work?
Well, closing the public hearing is a simple majority of the board, and then making a decision, to overturn would be a supermajority of the board. So what you're suggesting, I think, is possible. If you want to hold a finding and then continue the hearing, if the applicants will mutually agree for an extension, I think that is definitely a possibility, and we could see if the building inspector wants to do that. Is that what you're suggesting?
Yeah, so that we're not in the legal position of trying to override the building commissioner. If the building commissioner understands the board's desire to hear this, but the board's recognition that it was out of date, then we could sort of give the town an opportunity. And I don't know if that then shoots us in the foot legally for some other reason, to reissue and respond in the adequate time. And then we go forward dealing with that new one, recognizing that this one was out of date. But we're not telling the building commissioner what to do, just sort of our desire, but not an order. So we're not overriding him. It doesn't need a vast majority. It doesn't need a super majority. It just needs a continuation of the hearing for 30, for a 30-day period to see whether we can close this one, open a new one, that kind of thing.
Okay, so I'm kind of slow. I'm slow on the uptake. So can you restate your what you're proposing so I understand it?
So my thought is that if we have a finding of fact that the current response to the current order was out of date, but we do have a desire to, as a ZBA, determine on the merits of the information presented to us whether this is out of site, whether there needs to be a site plan approval for this, pre-existing non-conforming change. But so what we're doing is we will continue the hearing for 30 days to see if it gets resolved between the applicant and the building commissioner, whether there can be a reissuance and a timely response. And if not, we'll reopen this hearing in 30 days, one way or the other. So we can, if it goes, there's no new one, then we reopen it. We say there's no response, we're done. But if there is a reissuance, then we can open it and say, hey, there's a new one. Let's close this one and open that one, kind of deal. So it's a way of, so what I'm looking for is a way of complying with the law and doing the right thing for the applicant, which is hearing whether they're doing the right thing based on the bylaws of the town, not whether they were a day off in their appeal. And I understand legally we have the right to say, sorry, your day off. There's nothing we can do about it. But I don't think that's the right thing for us to do. So I would like, I'm trying to thread the needle of what's right and what's legal. So I guess that would be the question, is if we continue the hearing and everybody sort of agrees to say, let's do it the right way, we'll get it done, and then we'll do the correct process of hearing and make a true finding, versus, sorry, we've got to go to court in order to then, get to the place where we're either the applicant is screwed and they've got to go through, you are out of bounds, so go through everything without us doing, we've got to go through the legal case to get there, or, hey, they overturn it, it's out of our hands then, I guess, if it goes legally, if it goes through a legal path. I understand that I think it's within our right to do that, but I don't think it's the right thing to do. So I'm looking for a middle ground.
Okay. I think I now understand where you're coming from. Thanks for restating it. I probably just needed to hear it a couple times before I start.
Yeah, no problem. Yeah, so, it's the things that are floating around in my head to make sense of life. But
okay, but I just have a question for you, and then I'm going to go to town council. And sorry, Mike, I'm going to go to town council, then to you. So are you leaving it up to the building inspector to write another enforcement letter to appeal?
Yes.
Okay.
Yes. So I would say we are going to continue this. Our desire would be that this clears itself up in the 30 days that we're leaving this hearing open, but it is the hearing for what we have before us today. So if something changes in the next 30 days, then we can take that into information when we reopen this hearing, and we might be reopening another new notice on the next finding that potentially a building commissioner could go, and that the legal counsel could respond to.
Okay.
No.
Thank you.
I would leave it open so that we're just saying, hey, this is our finding of fact. We're pretty sure that it's out of date. Gee, will something change in the next 30 days?
All right. Thank you, Than. So I just want to turn to our attorney and ask Attorney Eichmann, does that sound like a course of action that would be legally defensible? That we would say this enforcement letter is out of date and we don't have jurisdiction, but we will leave the hearing open and continue it until the next meeting. And in that time, if the building inspector wants to write another enforcement letter and extend the date, and we can convey by motion through Alec to the building inspector that is the majority opinion of the board, we could, so he would be so advised, and then we would come to the next meeting, and if there is a new letter with a timely appeal, a fresh application, we would just go on and hear the appeal. Does that sound like something we can do, Attorney Eichmann?
Thank you, Mr. Chair. There's more than a little bit of novelty in that approach. Let me sort out what is clear. What is clear is that the board absolutely can vote to continue this hearing. You have time to do that. I think your 100 days runs out, and I wrote it down. I think it's August 7th. So if you're going to continue and keep this open, you want to keep that in mind. You can obviously get an extension of that time from the applicant. That would be the time for decision. But if you want to continue the hearing within that time period, you can do that on your own. Number two, the board can certainly make a motion and vote to request the building inspector, and I would frame it to withdraw his prior order and to reissue it. It's certainly something Kenny can do. Prior comments were that he is not required to do that. That's correct. He is not, but he can. Then we get to the really difficult question, which is, if he does that, is the board then free of the jurisdictional argument? Does that count as a restart, assuming that, of course, he reissues the order and then there's a second appeal? That I don't feel very confident about. It's possible, given that the building inspector would, if he was willing, be involved to actually withdraw that order. In essence, taking a different approach to the idea that, as Member McCormick said earlier, that there is a possibility that the board could affirmatively waive the jurisdictional argument. In this case, they would be getting assistance from the building commissioner to do that. I don't know. I can't tell you for certain. I know that there is certainly out there case law that if the building inspector issues one order, then he issues a second order, then he issues a third, and somebody says, well, I only appealed the third one, so you don't get to count the first and the second, that argument's not going to fly. But if the building inspector firmly says, no, I'm withdrawing that, I'm now reissuing, I'm starting afresh, at least there's an argument that could restart the clock, so to speak. But I cannot tell you that I'm very confident that would be successful, but it's certainly worth an opportunity to try.
Thanks, Jonathan. Michael?
Just along the lines of what counsel was saying, I guess, being a simple engineer and not a lawyer, I struggle with the concept of the board, or with the concept that the building inspector can restart the clock by shuffling the paper around and reissuing the same order in the same language, and therefore restart the clock, because otherwise, any decision that comes out, you miss your appeal, you go to the town official and beg, pretty please, reissue the same thing over again, and we'll start over again. We can't keep. I struggle with having the clock keep being reset forever.
So
also, we don't have the authority. We can't tell him he has to reissue it, because that would actually be a appeal of his decision, saying that his previous decision was invalid. So I don't like the look of that path. I know we're trying to avoid. I think we have to make the hard decision as to whether or not we decide it's late. If it's late, do we decide we can pick up jurisdiction due to equity or other orders, or not? And we have to bite the bullet and make that decision. And then, as Sean was saying earlier tonight, how one votes on the jurisdiction order, I think, has absolutely nothing to do with how one may ultimately vote on granting or denying the or upholding or denying the inspector's decision. So that's all I have to say on that one.
So, Than, is your hand up?
Yeah.
Oh, okay, go ahead, Than.
So, Michael, to that point, I wouldn't have him, as you were saying, issuing the exact same thing again. I would agree, it sort of can be problematic. But if we say, hey, it would be great if you withdrew it, clarified the when you have to respond language, and reissued it, so that it is a different order with a different language. That last paragraph, it's the same functional thing, but it would then clarify which thing is binding, which timeline is binding. So that may be a way of saying it's not exactly the same order, covers us that way. So that's a thought.
Thanks, Stan. Paul Robertson?
Yeah, I guess I would add that, there's no desire absolutely on the part of my client to keep on spending legal fees and engaged in, serial requests for the issuance of this letter. The request is simply very straightforward, to issue the letter with the correct instructions on the date to file. I think I want to mention too, that my understanding would be, there are findings of fact and findings of law. And the finding of fact would be that, the claimant did not file within 30 days. That's different from a finding that, that it was untimely, because I certainly have arguments, that I would, pitch to the court here as to why, in fact, the law does permit a client to follow the directions on the order itself. I think I'd also comment that, with respect to Attorney Eichmann's comment that, he's not sure what would happen here. I do point to a case called Cornell versus Michaud, or Michaud, however you want to pronounce it if it's French. And that's a case 79 Mass App Court 612, Cornell versus Michaud. And in that case, the court said that the original order was void ab initio, right? And so if it happens to go to court, and again, I don't want to, I'm hoping we reach a resolution, I would argue that this original order with it's not simply an over-the-counter description of where the deadline runs. It's in fact in the face of the order itself that, it says 30 days from the receipt of the decision. So, my humble suggestion would be that that the board, as a couple of board members have suggested, make the request to the building commissioner here. And as you said, he's not a lawyer. He may have made a mistake here. I think equitably there wouldn't be any resistance. I don't know what would happen, but it would seem to me that the request could be made. If that doesn't go forward, the board can quickly come back and say, okay, look, we're going to deny this on the timely grounds. But again, it seems like a path that allows all of us to move forward quickly without me having to go to court and argue the void ab initio arguments or the reliance on this case. And again, it's my client's desire to move forward as quickly as possible to resolve this, but to be heard in the merits as well.
Okay, thank you, Attorney Robertson. Adam.
Thank you, Mr. Chair. So I've been thinking for a couple of minutes now how to say this sort of tactfully to the board, but I'm here representing the building commissioner, and so I've got to represent his interests, and so I'm going to say it and hope that it's not too offensive. I appreciate that there may be a solution here that makes the decision easier for the Zoning Board of Appeals. That doesn't put you in the position where you have to determine the jurisdictional issue even before you get to the merits, if you do get to the merits of the case. But I think it's your decision to make. Certainly, if you choose to go in a different direction and to make a request, which will be communicated for sure to the building commissioner, that the commissioner withdraw or rescind the pending determination order and reissue it to allow for renewal of the appeal without the jurisdictional issue, because presumably that second appeal will be timely filed. You can make that request. I'm going to have a difficult time when the building commissioner looks to me for legal advice, because again, it's not my role to play equities here or to decide what should or shouldn't get to the ZBA or what the ZBA should or shouldn't have to determine how the merits get fleshed out, where the equities lie. My role is to give the building commissioner advice as to whether it's in the building commissioner's best interest to either do what the board is requesting, which is to rescind and reissue an order, thereby subjecting it to a new appeal, essentially facilitate an appeal on the merits, or to stand by the decision he's already issued, which, in the course of giving him instructions, telling him what you'd like him to do, you're also going to be telling him that's because you don't believe you have jurisdiction. When he hears that, he's going to know then, if you don't have jurisdiction, that amounts to you affirming his decision because you can't hear it on the merits because you lack jurisdiction. So it's a tough sell for the building commissioner to say reissue your letter, thereby opening up your decision to a review by the ZBA on the merits, as opposed to standing by your decision because the applicant missed the appeal period and that decision can no longer be challenged on the merits, and therefore that decision stands.
Okay, thank you, Attorney Costa. I have you guys in order, but I also have seen other hands being raised, and but I only saw board members. I don't know why. If someone, Alec, could you keep your eye out for other hands if there's other people raising their hands? Because all I'm seeing are the usual suspects, so to speak. Michael Toops, it's you're next in line.
All right, just a quick thing. So if the path was that the building inspector wrote a new order, and we continued the hearing, wouldn't we have to open a new hearing because it would be a new order that was being appealed, not the previous order we're currently hearing right now?
Yes.
Probably. Jonathan, I'm gonna go to you, and then I'm gonna go to Stefano, and then I'm gonna ask the board. I might not be doing my job as a chair by not moving this question forward. So I'm gonna try. I don't want to offend anybody, but Jonathan, can you answer that question? Could we just continue the same hearing with a new letter and a fresh application, or do we just now have a new notice requirement and a new 2 weeks and the 100-day clock starts all over again and so on?
Thank you, Mr. Chair. I think the latter. I think it has to be a new appeal has to be filed. I think notice should be issued. The public hearing should be reopened, and this present appeal would have to be dealt with separately, whether by withdrawal of the appeal or otherwise. And we can talk about how that might happen. But I think it's a separate appeal. It wouldn't really be melded into this one.
Okay. Thanks, Jonathan. Stefano?
Yeah, so I just want to be clear on one thing, and this is just how I'm thinking about it, and this is in response to Attorney Costa's comment with respect to the determination that the board has no jurisdiction, and that's when it would go back. Again, I think if we make a finding of fact that it wasn't timely filed and the jurisdictional question, those are two separate questions. And so I would not want to make the jurisdictional question. I would want to continue the hearing and allow for the opportunity to not have to make that decision. Because if we make the jurisdictional, that's the complication we're trying to avoid, right? That's the dynamic that I'm hearing all night here is that the jurisdictional determination has arguments on both sides, and frankly, town council is most likely the advice that I would follow as a board member. So my thought is we wouldn't even decide on that. We would just submit for a continuance. If the commissioner wanted further direction, either we provide that as town council suggested with respect to a request to consider reissuance because we have determined that it was filed late, and then provide maybe commentary with respect to the last paragraph and why he should reissue it. But that's it. I just kind of wanted to comment on that.
Okay, so just to be clear, then that would mean we would continue it, and if a letter was to arrive, we would still have to close the hearing and say we uphold the building commissioner's original letter, or he would have to withdraw it, right?
No, he would have to withdraw it. Yes.
Right.
If he doesn't withdraw it, then we're back here, and then we move forward with deciding.
Okay, and if he does withdraw it and gives us a new letter, then I guess say that this hearing is now closed because the application or the building commissioner rescinded his order. So there's nothing to overturn or uphold. And then we would have to wait for a new application, and we would have to then notice it and then hold another hearing.
Yes, that's my understanding.
Okay. Anything else, Stefano, before I go to Sean?
No, thank you.
Okay. Sean.
Mr. Chair, I think Ms. Vorse was ahead of me.
You know what? I knew there was people out there I couldn't see. I don't know why I can't see Kathy. Kathy, go ahead. I'm sorry about that.
Hi, thank you, Sean. Comment. I want to thank Attorney Costa for actually directly answering my question as to what would happen if you decided that it was untimely filed, you chose not to hear it, and he answered my question. I appreciate that. I am also very impressed with how interested you are in wading in on this one. And I served on the planning board and then the ZBA nigh on to 40 years ago, and was coached by then town council that you sit as a quasi-judicial board. So you think of yourself as a judge on the merits of what comes before you. And to me, the hybridized kind of solution you're trying to come up with, it is problematic from my point of view. You either take it or you don't. And if you hold that imagery of sitting there as a judge, I mean, very seldom do you see a judge trying to, send it back to somebody who doesn't have to comply and all. So then as one individual planning board member, I reiterate my comment that I would like to see this applicant comply with the zoning bylaw. I don't speak on behalf of the entire planning board, but that's my piece. Thank you.
Thanks, Kathy. Sean?
Thank you, Mr. Chair. Just on the question of jurisdiction, because I think that's where we're headed. I think I also appreciate that we're trying to think sort of creatively about this. I'm not sure that it's going to happen. On the jurisdictional question, I guess I want to make 2 points. The first is that there is a toehold in the case law. If a jurisdictional defect is waived because nobody mentions it, then it's waivable. Because there are other types of jurisdictional defects that even though nobody caught it at the time, you could go all the way up to the highest court years later, and they say, wait a minute, you never had jurisdiction in the first place. And it goes all the way back to the beginning. So there really are 2 different types of jurisdictional defects. We have a legal toehold here. I understand and I appreciate our town council's point that, look, guys, it's weak. I mean, it's weak. It's not a well-developed argument. It would be difficult to defend. But this kind of gets to my second point. Why do we think it's something that would have to be defended? I mean, if we assert jurisdiction and we find in favor of the building inspector and the applicant appeals, the jurisdictional issue is not coming up. And if we find in favor of the applicant, I don't imagine the jurisdictional issue is coming up. So I think that, I think we are getting great advice from town council that if this is a jurisdictional defect and if the board felt strongly about not hearing it because of the defect, I think every judge in the Commonwealth is going to side with the board on that one. But I think that there is a second option. I think that it's definitely not the obvious, well-settled option, but I think there's a toehold in the law. And so I think that we should assert jurisdiction. And I just, frankly, I don't think any of these workarounds are going to work. I think we've got to make a call here. And that's the call that I would suggest we make.
Well, I would agree with Sean in part, at least with the gymnastics that we're trying to do here. And I am, I don't look good on the uneven parallel bars. So I think that we maybe should either if I have stated my position on the jurisdiction issue and the timeliness issue. And if I'm the minority, then I will vote in the minority and we will move forward. But I think, is there anything else that anyone would like to add before someone makes a motion? Because I'm trying to be the stern chair now and just demand that we move forward because I think we're just grinding. So is there anything else anyone would like to add? In that case, I'd like a motion not to close the hearing and not to continue the hearing, but just a simple finding of fact on what we should do with respect to the timeliness of this application and whether or not we should hear it. I think, and I'm gonna let Sean clarify it, but I think Sean is saying that we're estopped, and it's an equitable estoppel because the letter had incorrect information on it. Is that what you're saying?
No, Mr. Chair. I think what I'm saying is that there is support in the case law that the 30-day appeal period from a building inspector's order is not the type of absolute hardcore jurisdictional defect that would prevent us from ever hearing. And the reason I think that is because there's one land court decision that cites to an appeals court decision where there was a jurisdictional defect that nobody raised, nobody sort of caught it, it wasn't on anyone's radar. It got raised later, and the court said it's too late. And I think that if you follow that logic, if there's a time when it can ever be too late, that means it's not the type of thing that can never ever be overcome. And so if I were to make the motion here, my motion would be that the board asserts jurisdiction despite the exceedance of the 30-day deadline under the authority of the Plotka House case in the cases cited therein. So that's how I think I would frame the motion.
So moved. I'm just kidding. Do you want to make that motion, Sean?
Sure, I'll make the motion, Mr. Chair. So okay. I would move that the board hear the merits of the appeal of the enforcement action, despite it being filed outside the 30-day deadline set forth in Chapter 48.
Is there a second?
I'll second that.
Is there discussion? Michael Toots.
I guess I come back to the question, which I struggle with, is does the board have the discretion? The case cited was the board didn't even know that they were past the deadline, but the fact that we've been discussing the deadline for quite a little time right now means that the board is not ignorant of the deadline. So if we're aware of the deadline, are we legally allowed to waive it? That's what I'm struggling with. Over.
I would suggest that it's better for a board to knowingly waive it than accidentally waive it. And I think the courts have upheld the accidental waiver. And I would suggest that in the right case, the courts would uphold an intentional waiver.
Okay, is there any further discussion on the matter? Kathleen?
Just what kind of precedent does that set for your board? Would be the question I put up there.
Point of order, Mr. Chair. There's a motion. It's been moved and seconded. I'm not sure public comment is appropriate at this point.
I would agree. I'm sorry, Kathy. I agree with Sean. That is an actual procedural issue. So we will stay with the board. Is there any other questions? Although I will echo Kathy's point as a board member that what kind of a precedent, although we do not set precedents, this will be something that we will be reminded of in the future. But and that's all I have to say on the matters. Does anyone else have any other comments? And I'm hearing none, so I think it's time for a roll call vote. Sean McCormick?
McCormick, aye.
Stefano Caprara?
Stefano Caprara, aye.
Michael Toops?
Michael Toops, nay.
Sand Stunts?
I'm gonna vote nay.
And Mark Barbadoro, nay. Okay, so a majority of the board has decided that we don't have standing. Is there another motion that someone would like to make? Or we don't have the jurisdiction, whichever. I'll leave that to Sean.
So I guess the next motion would be that we as a board find that we don't currently have jurisdiction because we do not have jurisdiction over this because it's outside the 30 days. So if we have a finding of that, I will. If we have that, then I will make a motion to continue the hearing and recommend and put it together. So I think what I would like to do is have the two. I know it's a funky path, but have a motion that we as a board don't have jurisdiction over this application, this appeal, because it was filed outside the 30 days.
Shoot. I'm sorry, Dan. Can you say it one more time for me so I can understand it? I lost my train of thought and I'm sorry.
Yeah, so did I. It's okay. I would make a motion, a sort of a motion of understanding. I don't know whether it's a motion or it's an understanding of the board that we do not have jurisdiction because the appeal was filed outside the 30-day window as stated by statute.
So it's essentially the opposite of what was.
Yes.
Okay.
So, and then just so, I mean, I think I can do that. And then just so people know, I will then make a motion that we recommend that they withdraw this and file a new one. Because I think that's the right thing to do. So
you mean the building inspector would withdraw his letter and we would request that the building commissioner withdraw his letter and write a new one with a fresh date and we start afresh. Okay.
Right, but I think the first motion is that we as a board have an understanding that based on that the appeal was filed outside the statute of limitation, the statutory 30 days.
So you have that motion on the table and you will come back later pending the outcome of the first vote with a second motion.
Yes.
Okay. So there is a motion on the floor. And so, Michael, I did see your hand up, but now you get first crack, but you have to speak to his motion.
Point of order. We just voted the motion that said that the board does not have jurisdiction. This seems to be a redundant motion.
I feel the same way, but.
Yeah, Mr. Chair, as I heard that, Member McCormick made a motion that the appeal was filed late, but that the board would hear the merits of the appeal regardless, taking advantage of the case law that he cited, although that's not, the last part is not part of his motion. That motion failed by a vote of 2-3. I think for clarity's sake, I would not treat that as a definitive motion on the application. I think if you're going to vote on the appeal, I think you need a motion at this point that says move to deny the appeal based on the finding of the board that the appeal was filed more than 30 days after the date of the order.
And you think we can do that without closing the hearing?
Oh, absolutely.
Right.
Yes.
Okay. Okay.
So if we have that motion, a motion that says we're denying it based on that, and we keep the hearing open, we can then have a different motion later that says, hey, it's something has changed. We're changing our motion on this hearing, I guess. Or there'd be just a new.
Can you speak to that?
Yeah, that's an interesting point. So the board holds the appeal in its hands until it files its decision with the town clerk, which it's required to do on an appeal. It's required to do that within 14 days of making its decision, and ultimately within 114 days of the date of the application of the appeal. So if you take a vote now that says, okay, we are denying the appeal because the appeal was filed late, that vote stands at this point, but the board would be essentially, without filing a decision, would be holding that in abeyance while it asks, apparently, it would then have to ask the building inspector to do something different, hoping that it would then come back within the 100 days, unless it was extended, and would have to rescind that vote. It's going to have to deal with this application one way or the other, but that vote would stay there until you turned it into a written decision and filed it, or took it back, or reconsidered it, or the appeal was withdrawn.
And again, just for everyone, on a side note, if the appellant decided to apply for a special permit, he's within his rights to do so, provided that he meets special permit criteria. I just want to lay that on the table here. So, Fan, is that what we're going to do?
I think that's the next step. Yeah.
Okay, so in that case,
I guess it's the 14 days that. So I'm flying to Barcelona on Thursday, so 14 days becomes pretty hard for me to get another hearing in the next 14 days. So how does that 14-day clock run?
Well,
or do
here's the thing.
Yeah.
The 14-day clock is for notice, right? You got to notice two weeks apart, right?
No.
And then
it's the filing of the decision. So if we make a decision, it needs to be filed with the town clerk within 14 days. So we don't have a whole lot of window to change that if I'm out of the country for the next 10 of those 14 days.
Yeah, Mr. Chair, you can extend that 14 days. That's
okay.
As long as you don't run by the 114 days.
Right. So we could make that 30 days. We could make that 30 days, create a 30-day window of filing of that decision. So we could make a binding decision today with a 30-day ticking clock where we could overturn that decision within 30 days if need be.
It'd be less than 30. You got till August. Well, yeah, no, I think you're right. That would work.
We could also get an extension, right?
Yeah.
Correct. Right.
Okay. I would be loath to do anything without an extension.
Mr.
Alex.
Chairperson, I will note for the board that between your last public hearing date and this public hearing, at your last meeting, you did agree to an extension with the applicant. The applicant provided a letter. We countersigned said letter and filed it with the town clerk, and it included an extension of the board's deadline for decision in equal number days as we extended this public hearing. So that was a 28-day extension between your last public hearing and this date. You applied 28 additional days to your August 7th deadline. That puts you at September 4th.
Okay. So there's a motion on the table, yes?
So I will make a motion that we find that we do not have jurisdiction because the 30 days on the appeal was not met, and that we will delay filing that with the clerk until after our next public hearing.
And Alec, we have enough time for that?
So long as you open your next public hearing before September 4th, yes, you should be within your range to do so.
Okay, is there a second to this motion? Again, is there a second? The motion does not carry. Okay. Michael Tubes.
I move that we deny the appeal due to the fact that the filing was not filed within the required 30 days, period.
Is there a second to the motion? I will second the motion. Is there discussion? I hear no discussion. All in favor?
But before that, what happens if this one doesn't pass?
Well, that's an interesting question, and I think we should get the Attorney Eichmann to weigh in, because I think it matters whether or not it passes with only one vote or two votes. But go ahead, Attorney, unless some board member wishes to speak. No, okay, Attorney Eichmann, and I'm sorry I'm moving quick. I'm getting cranky.
Yeah, no, thank you, Mr. Chair. I mean, this is a motion to deny the appeal. You need 4 votes to approve the appeal. In my opinion, if you get 2 votes to deny the appeal for this reason or more, I think the appeal is denied, particularly if you close the hearing thereafter and file a decision.
Okay, now we have our answer. With that in mind, does the board members have anything they want to add?
So just 2 votes in favor denies it. It passes with 2 votes. Is that the
right.
Essentially?
Yeah, it doesn't sound right with parliamentary procedure, but because the motion requires to pass this, it requires 4 votes. A motion to deny that gets 2 votes means that a motion to pass it cannot possibly pass.
Gotcha.
And just a comment, and this is just how I'm looking at it. I don't know if I'm doing it the right way or not. In light of the last vote that the board took, I feel that this decision is relatively straightforward. But I don't know if I'm interpreting that the right way. I take the decision of the board at the last vote to impact my interpretation of this next vote.
Nothing is ever clear cut with this board. You know it. Just, I don't know. I've never seen in my, 16, 17 years of supporting ZBAs, ones that, have such intricacies and nuances in their decisions. So, but with that in mind, we have a motion on the floor. Would anyone else like to make a comment? So, and I'm going to make a comment. So it sounds like from council, if 2 people vote yes, then the petition to overturn the building commissioner's decision is denied. So two
Yes.
affirmative votes. Is that right, Jonathan?
Yes, Mr. Chair, and I would follow that up with a motion to close the hearing.
Okay. So we are in the middle of a discussion. Does any board member have anything else to add?
Sorry, just one thing. Are we making, I mean, I know Than mentioned it. Do we have to make any comments with respect to any reissuance or anything like that? Or no? That's not on the table for this. Okay.
So it would just be issued within the regular 14 days.
No, I'm talking about the building commissioner.
I think the hearing is still open. If you want to make a separate motion, you can make a separate motion before we close the hearing. How about that? So we just keep it clean. If you want to make a different motion other than upholding the building commissioner, if you want to give him advice, like a
No, it's okay. I got it. Yeah, I got it. I'm good.
Okay.
Thank you.
All right. Okay. Any other comments? Okay. Roll call vote. Michael Toops.
Michael Toops, aye.
Dan Stunts.
Dan Stunts, aye.
Stefano Caprara.
Nay.
Stefano Caprara votes nay. Sean McCormick.
McCormick, nay.
And Mark Barbadoro, aye. Okay. So, Stefano, did you want to make any other motion? I didn't want to interrupt you.
No.
Oh, you're good.
No further motion.
Okay. Does anyone else have anything they would like to do before we close this hearing? Attorney Robertson.
Thank you very much. I first want to say, thank you. It's obvious that the board spent considerable time, considering this. It's a shame that it's 9:40 at nighttime, because I think that there were some options that could have been considered. I think, were feasible here. I think that, in some extent, we're sort of, driven over a cliff here, right? That I have to now go and appeal this order. And I think that there were equitable results that could have been found. So I think it's on behalf of my client, I think that this is having to go to court to resolve this, when we could have come to a resolution that I think would have moved this forward in a manner that protected everybody's interest. It's a shame that wasn't reached.
Thank you, Attorney Robertson. And also just one final reminder that the other alternative is a special permit. You don't necessarily have to go to court to get what your client is looking for. So, any other comments? If not, I'd entertain a motion to close the public hearing. Michael Toops. Okay. Is there a second?
Second.
Okay. Moved by Michael Toops, seconded by Sean McCormick. Any discussion? Hearing none. Yeah, I do have something to add, actually. So I'm going to ask, and what I would like to do is just get authorization from the board to sign the decision by myself, unless the board wants to sign it individually. Would you mind withdrawing or suspending your motion?
Withdraw the motion to adjourn.
Okay. I would entertain a motion to allow the acting chair to sign the decision.
Move to allow the chair to sign the decision. Acting chair to sign the decision. Over.
Is there a second?
Second, Mr. Chair.
Okay. Any discussion?
Or you're going to make me clear.
Okay. Hearing none. Roll call vote. Michael Toops.
Michael Toops, aye.
Dan Stunts.
Stunts, aye.
Sean McCormick.
McCormick, aye.
Michael Toops. Did I already say you?
Aye.
You got
Am
my
I missing
vote.
anyone? Stefano Caprara.
Stefano Caprara, aye.
And Mark Barbadoro, aye. Would someone like to make a motion to close the public hearing?
So moved again.
Okay. Seconded. So it's moved by Michael Toops, seconded by Mark Barbadoro. Any discussion? Okay. Hearing none. Michael Toops.
Michael Toops, aye.
Sean McCormick.
McCormick, aye.
Stefano Caprara.
Stefan Capra, aye.
Than Stunts,
Sun's eye.
and Mark Barbadoro, aye. Okay, thanks, everyone. We still have the meeting is still open. Is there any business that the board would like to discuss? Sean, Alec?
Thank you, Mr. Chairperson. A note for everybody that you do have another meeting scheduled in the month of July. Let me just go ahead and get this pulled up. I want to confirm the correct date while I have everybody here, just given summer schedules.
The 23rd, right?
I want to make sure I'm giving you the correct one. So here we go. Sorry, everybody, the servers move slow. That is correct, July 23rd.
I'm moving slow too. July 23rd, that's our next meeting. Okay.
I can't. I'm not going to be there, but just I think I already sent an email about that.
Okay. Than, can you make it?
Yeah.
Awesome. Well, then we should be in good shape. All right. Do you want to close the meeting, anyone?
Just, Mr. Chair, before we do that, I want to revisit the rules and regs for a second.
Sure.
Not substantively, I promise. It's too late. My understanding of the process was that the individual board members were going to submit the sections that they were charged with, and then we were going to get one document that would become a public document that had all the, everyone's comments on all the sections. Is that still the plan?
I think it is the plan. Yeah.
Okay.
Yeah, we give our comments to Alec, right? And Alec, everything. And then we see it. Okay.
That's correct. At the conclusion of this meeting, I'm going to go ahead and recirculate the annotated draft that Mark Barbadoro prepared ahead of your May meeting. That was the draft we were then going to move forward with reviewing individual sections, integrating the appropriate sections as that board member felt reasonable for their section. And then in any format, you can send me back your sections, whether it's just that specific chunk, whether it's the whole thing with your revisions to your sections alone, whatever it looks like, I will then compile it together. To date, I have received 3 responses. We're still waiting on a couple more.
So I just want to also point one thing out, that when I did the side-by-side, that did not necessarily contain every paragraph of the original. Okay, I was just comparing things that were similar. So there is actually one more round when we're done, which is to take our original one and what never made it into the document, then decide if we're going to move those in as well. So I just want to let everybody know that. Okay. Anything else we need to discuss? I'm seeing nothing. Does anyone want to make a motion to close the meeting?
Motion to adjourn.
Okay.
Second.
Is there a second?
Second.
Okay. Motion by Sean, second by Than. Any discussion? Hearing none. Sean McCormick.
McCormick, aye.
Michael Toops.
Michael Toops, aye.
Than Stunts.
Sun's eye.
Stefano Caprera.
Stefan Capra, aye.
And Mark Barbadoro, aye.